Good morning, everyone. Or I guess could say good afternoon, depending on what time of day this webinar is actually going. But today we're here to talk about Uber meets Michigan no fault. I'm Nate Edmonds, and unfortunately you don't get to see my wonderful face today. You're going to look at some great slides, hopefully, and I'll get this done quite quickly for you. So as we move along, we'll get this thing going for you real quick. Also, if you have any questions, feel free to write them down as you go and submit them to me by email or give me a call, and I'll be glad to answer them. So without further ado, let's get this thing rolling, I guess is the best way to say. First off, let's define Uber. Uber is a wonderful company that started out of San Francisco as a background information. Began in March of 2009 from Travis Kalanick and Garrett Camp. Currently, they serve it worldwide. Uber was first founded as Uber Cab, and the app was released in June. It raised $49 million in venture funds by 2011, and beginning in 2012, Uber expanded internationally. In 2014, it experimented with carpooling features and made other updates. It's continually raised additional funding, reaching $2.8 billion in total funding by the beginning of 2015. Many governments and taxi companies have protested Uber, alleging that its use of unlicensed, crowdsourced drivers was unsafe or illegal. This creates our wonderful dilemma that we currently have under Michigan no fault. What is Uber? I've given you a website here to look up, a Wikipedia. Also, there's other companies that wonderfully fall under this type of agreement. We have Lyft, Sidecar, numerous other companies that have come into the marketplace. The biggest issue is how does it affect your BI limits as well as your first-party no-fault benefits underneath Michigan no fault? Hopefully I can answer some of those questions and give you some ideas in the way to handle these wonderful claims, because I believe that we'll start seeing a proliferation of these type of claims here in the very near future as more and more people begin to use these services. Well, of course, since Uber began in San Francisco, we have the fact that California took the wonderful lead in trying to legislate and take some type of control back from Uber. This results in us having the legislation that I have attached a link for you, where California has defined Uber, Lyft, etc. as a transportation network company. This is probably the most important definition as it relates to Michigan PIP benefits, as we have the word taxi defined in the no-fault section, but we do not have the term transportation network company defined anywhere. According to California's current regulation, a transportation network company is a company that uses online-enabled platform to connect passengers with drivers using their personal, non-commercial vehicles. This has also been called real-time ride-sharing, but it's different from traditional ride-sharing in that it does not require the sharing of a vehicle by multiple riders to reduce vehicle trips, traffic congestion, and other automobile emissions. I guess for the lack of a better term, a taxi cab can provide the similar services, but while most cities require companies which provide taxi cabs to meet requirements for business, transportation network companies may be exempt from such requirements due to their only providing a marketplace and not actually employing drivers or keeping automobiles. That's the key definition here under Michigan no fault, is what does Uber actually do? Since they do not actually employ the drivers or keep automobiles, that is how they're skirting the wonderful taxi definition under the Michigan no fault statute. Since they're skirting the outside of the lines, or I guess a lack of a better term, the blurred lines from a great song that has just been recently termed. We now must deal with the term transportation network company. Uber and the other companies have attempted to require driver background checks, driver training, drug, alcohol policies, minimum insurance through the Public Utilities Commission in California. Well, as you know, California and any regulations or attempt at legislation always needs to have changes made to it as we determine whether this is a workable law or not a workable law. Well, in California, the law first went into effect in 2013. On September 17, 2014, California's governor approved a new bill that becomes effective this July. This bill will amend the Passenger Charter Party Carriers Act to enact specific requirements regarding liability coverage for transportation network companies. They require certain coverages while a vehicle is in effect and then while it's not in effect. Well, since at least one state has taken the lead in it, I guess the next thing is, how does this affect Michigan and what we do? This leads us to our next aspect of what is Michigan currently doing. And currently, Uber launched in Michigan in March of 2013. We have 5 other cities that have been at it in 2014. Grand Rapids, Lansing, Ann Arbor, Flint, Kalamazoo. We have one other company I know of, Lyft, currently operating in Metro Detroit and Ann Arbor, and I'm sure other minor companies are also trying to come into the marketplace. There was a new House Bill 4032, which was just recently introduced last month. This bill is currently sitting in committee. That means it must still go through the House and the full Senate before it gets approved. Then it must land on the governor's desk and hopefully it will be signed. Therefore, at the current time, we don't have any legislation in Michigan. Obviously, the legislation will alleviate some of the needs and concerns by requiring $1 million in BI coverage and hopefully provide PIP and PPI required by the No-Fault Act. There was the first attempt by a bill, and that was done last year. I've attached on slide 6 a link to the legislation. This bill originally provided for $1 million per incident in BI coverage. There was also a quote contingent coverage of $50,100 and $30,000 in property when the vehicle was actively transporting passengers. The policy then could revert back to a 2040 when the individual is logged in and not transporting passengers. Quite frankly, I don't know how an insurance company would write this policy. The legislation also required background checks, chauffeur's license requirements, safety inspections, and other aspects. It was also going to repeal the Limousine Transportation Act. That is quite interesting in and of itself, is that there's nothing relating to taxi cabs or calling this a taxi cab, and in fact more closely took Uber and the other transportation companies into a Limousine Transportation Act. This bill has currently died at the end of 2014. There were numerous reasons why that the bill died. On slide 7, I show you the wonderful history of the bill and how it began and how it ultimately was postponed throughout the Michigan legislature. It was attempted to be put through at the end of the session when some bills are rammed, quote unquote, rammed through when this would be a lame duck session. This bill, unfortunately, was not able to be signed through and done in very short order. The reason why it didn't have much opportunity, and you will note, is that there was no public hearings on it, was that a Lansing Democrat, Andy Shore, who opposed the bill, said it would override an Uber deal already done jointly with Lansing and a university town of East Lansing. The representative said that many local governments prefer to have their own agreements with Uber, Lyft, etc., rather than having state regulations on it. An additional reason is that some of these local cities also would like to put their own quote-unquote tax or receive some type of fees, as each city can with a type of cable. If you don't know that, your cable companies pay each city that they're in a regulatory fee. And I'm sure that many of these local municipalities would love to have a type of fee-based system if Uber, Lyft, etc. operates in their city, that they could receive some type of tax or money from the use of this system. This is why this bill has some problems, as well as the bills in the future, due to local municipalities wanting to have their own control. There are additional problems that this bill in 2014 had created. Matt Odie, a manager of Detroit's Checkered Cab, he was one of the outspoken proponents, as you may well guess, with taxi companies opposing this. They believe that Uber should be governed by vehicles for hire, i.e. taxi cabs. Currently, under the old bill, the driver's personal insurance would apply anytime the driver's app was turned off. During the trip, Uber's $1 million commercial coverage would cover a crash. However, Uber would not like that, as they did not want to be the owner of the vehicle or the employer, as then they would have some type of liability. Obviously, since we are all pretty well versed in the insurance arena, we can see the problems that this bill would have created. Additionally, the Insurance Institute of Michigan weighed in and asked lawmakers to delay action until 2015. The Coalition Protecting No Fault, which is backed by the Michigan Association for Justice, also known as the Michigan Trial Lawyers, stated that they wish to have $1 million of coverage all the time, period. Well, that would simply put the problem with having more coverage on a vehicle all the time in case they were involved at a crash, whether they are transporting passengers or not. As you can see, that is why the trial lawyers wanted more coverage. If this vehicle simply is being operated on its own, of course they want people to have more coverage. Simple reasoning. Since the death of that bill, a new bill has arisen. The new bill currently sits in committee, being just introduced in February of this year, and currently requires $1 million worth of coverage all the time, and took out those contingent liabilities of the prior bill. It has not been passed in the House or the Senate, and therefore will sit there for a period of time until it actually gets out of committee. Committee typically takes anywhere from 30 to 90 days. However, a bill can also die in committee, unfortunately. There may be public hearings that are going to be held, but as of this time, we have no legislation which covers a transportation network company or Uber or Lyft or whatever they call themselves today. Therefore, now we proceed to where are we today under Michigan No Fault with these wonderful transportation network companies or quasi-taxis or whatever you'd like to call them. Michigan No Fault law currently is that the PIP will apply to passengers, but there's a bigger question of whether this will qualify as a taxi cab under MCL 500.31142D, which makes passengers go to their home insurance first. The argument against them being a taxi is that Uber, Lyft, Sidecar does not employ these individuals, nor do they own the vehicles. They have been termed under Wikipedia and other states as a transportation network company. Therefore, the argument is that they are not a quote-unquote taxi cab. and therefore they would not apply to any of the exemptions listed under 500.3114, which is the priority statute in Michigan. Additionally, we can look to the proposed legislation, which is under the repeal of the Limousine Transportation Act. Remember, as I showed you previously, the legislation that died previously was going to repeal the Limousine Transportation Act. Under Michigan law, a limousine is not a taxi cab. That's MCL 257-1905 sub 3. Since the proposed legislation would repeal the Limousine Transportation Act, one could surmise or argue quite easily that this is not a taxi cab and therefore would qualify under a limousine. And therefore, since it is not a taxi cab, the priorities provisions of 500.3114 that apply to a taxi cab are not applicable. My recommendation would be that the vehicle is a taxi cab. Thus, passengers would go to their personal policy and other priorities first before resorting back to the Uber vehicle as a last resort. In this webinar, I'm assuming that the issue is most of the claims that will come to you will be the fact that we or you are maintaining insurance on the Uber vehicle. Or you may have claims made where someone was riding as a passenger in an Uber vehicle. Obviously, you will want to argue just the opposite of what I told you if you have a passenger riding in an Uber vehicle in an attempt to shift the PIP priorities to the Uber vehicle. This is where you have your difficulties with the current status or lack of status of Uber in Michigan. How to define the vehicle? Defining the vehicle obviously is the key to where the priorities would lie for first-party no-fault benefits, either with your passenger who is your insured coming to you for benefits, or a passenger in the vehicle attempting to come to the Uber vehicle that you insure. This issue has not been addressed in Michigan by any reported cases, and I'm sure it will become a more prevalent issue very soon in the near future. Obviously, there are arguments to be made for both sides in an attempt to shift liabilities for PIP benefits. However, I can help you with one of the issues, which is whether the insured of the vehicle being used as an Uber vehicle or the driver of the Uber vehicle, is he or she your policyholder? If this is the case and they are attempting to come to you for no-fault benefits or potential BI coverage, there are ways in which you may limit coverage or attempt to decline coverage in its entirety. I would indicate to you the case of Titan Insurance Company versus Heighton allows you to rescind the policy as to the policyholder if there's misrepresentation. If the insured or driver of your vehicle is not a policyholder, then that personal policy and ultimately back to this vehicle could occur. If you want to be aggressive, let's go forward. The most aggressive defense posture that you could take in regards to an Uber claim is rescission. This would have to be first to your insured. This involves you rescinding the policy, which is in essence stating that the policy does not exist and never existed between the insured and your company. The key questions and the key areas to focus on is, was there a misrepresentation in the application? Was there non-disclosed business use? Was the vehicle using for hire, which is in your application, or barred by your policy provisions? Obviously, the investigation that you conduct in the early stages will be key and critical. The most logical way is if there is an indication that this vehicle was being used for hire by one of your insureds and non-disclosed, a simple recorded statement can be done. However, it's recommended that an examination under oath be done so that this testimony may be secured and an opinion then done as to whether a rescission would be appropriate under the facts and circumstances. The Supreme Court case of Titan Insurance Company versus Heighton, 491 Mich. 547, allows you to rescind the policy, void ab initio, as if it never existed. All coverage would not be in force. You would have to refund the premiums for that policy period. Even the PIP as to that insured would not be in effect. There does not have to be any claim that the misrep could be easily ascertainable. Titan Insurance Co. versus Heighton did away with the requirements for easily ascertainable fraud. Therefore, if there's any type of misrepresentation in this regard, then we can rescind the policy, and the most logical aspect would be for the company to do that rather than beginning a declaratory action. This could also be done as if the company wishes. A declaratory action could be done to declare the rights of the policyholder as well as the insurance company. As stated previously, the investigation is key and critical to this defense, in that the underwriting file must be obtained as well as all documentation as to what the misrep was and when it was done. There are always landmines and problems with this, in that the insured could come back and indicate to you that he had spoken with the agent and that he told the agent and the agent never forwarded that on, which then creates an issue of errors and omission, and also invokes a case called Hart versus Farmers Insurance of whether there was a special relationship between that insured and the agent. That is an entirely another webinar, and if you have any of those questions, please feel free to contact me and let's discuss those in greater detail as we talk about the facts of each case. As it relates to your insured owner or operator who is insured under your policy, the case law is fairly clear that the rescission as to that individual is fairly straightforward. It does not appear to create many problems as it relates to the rescission, which then allows you to void the coverages as if they never existed for PIP benefits, collision benefits, and BI or UIM, UM coverages. However, as it relates to innocent third parties, the individuals who are in the car, the individuals that are struck by your driver, unfortunately, now there is a split of cases. Neither one of these cases are published, which creates more difficulties when you are trying to address these. However, as I've indicated to you, this is an evolving process, and I am hopeful that case law will be coming forth as these cases that I will cite to you in the next several slides have been appealed further to the Supreme Court level. Up until the end of February of this year, it appeared that rescission as to third parties would be allowed based upon the case of Frost and Citizens Insurance Company versus Progressive. That is an unpublished Court of Appeals decision. I've cited to you the docket number 316157. The Court of Appeals ruled that Progressive could rescind even as to innocent third parties pursuant to Titan versus Heighton. This opinion appears to deal with PIP coverage, which can be rescinded, as there were other levels once the policy was rescinded for which the injured party could go to. That being the case, there is always the Michigan Assigned Claims Facility for an injured party to go seek first-party no-fault benefits from. This case dealt with mandated PIP coverage and allowed the insured to rescind coverages as to the innocent third party, and therefore the individual could apply to the assigned claims facility even if the policy was rescinded, as they always had a last resort. The next case is State Farm versus Michigan Municipal Risk Management Authority, which was just recently issued on February 19, 2015. There was 2 combined dockets, and if you review this case or want a copy of it, I will gladly provide it to you, but the docket entry of 319710, the second portion of the opinion, is the key aspect to look at. This case does not allow rescission as to an innocent third party, and stated that Titan versus Heighton did not allow rescission, and the key language was so long as the remedies are not prohibited by statute, and cited several passages from Titan. This opinion went into quite a bit of detail regarding Titan, and in Titan versus Heighton, the insurer, being Titan, had acknowledged that they were only reforming the policy from their higher limits to the statutorily mandated coverage for BI limits of 2040. As you all know, first party no fault and BI are statutory, not contractual. Under the State Farm case, the UIM could be rescinded, as that is an optional coverage. However, the BI must be reformed to the statutory minimum of 2040, and you could not cancel PIP as to innocent third parties. Therefore, we have a wonderful split of authority, as we have 2 competing opinions. Neither one are published, and therefore neither one have precedential value. Both are purely persuasive in arguments. However, I will give you a few thoughts regarding what is important between the 2 cases and any attempt to differentiate. I'm going to take you back to the Titan versus Heighton case, which had some interesting language in it. In Titan, the main statement by the Michigan Supreme Court was put on my slide 15 at the beginning. As between the fraudulent insured and the insurer, there can be no question that the former should bear the burden of his or her fraud. They cited Note 13. Note 13 further continued that it should be noted that the public is not powerless to protect itself against this situation. Optional uninsured motorist coverage allows an insured to recover from his or her insurer to the extent that the insured would have been permitted to recover from an at-fault uninsured driver. In this case, the Holmeses, in fact, purchased this additional coverage. Well, this then bears thought as to which case, either Frost or State Farm, covers this issue. Since Titan versus Heighton seems to indicate that the fraudulent insured who did the misrep to the carrier should bear the burden of his fraud, and not the insurer having to provide coverage for which they would not have contracted, it would seem that the Frost case, which allows rescission as to innocent third parties, would be the best line of thought. However, and there's always that wonderful however provision, and before I go to that, the last quote is where the Supreme Court said that they reaffirm the principles set forth in Keys and hold that insurers not precluded from availing itself of traditional legal and equitable remedies to avoid liability, even when the fraud was easily ascertainable and the claimant is a third party. So it seems that they're going down the wonderful line of allowing rescission in all cases, even as it relates to an innocent third party. But, and there's a wonderful but, as we always say, earlier in Titan, the Supreme Court said the remedies available to Titan may be limited by statute, and they cite Rollman, which is a prior Supreme Court opinion, at 442 and 525 Note 3. Titan further goes on, and in Note 3 says, for example, MCL 500.30091 provides a policy coverage minimums for all motor vehicle liability insurance policies. That is probably going to be the key language that is going to be given to you to not allow rescission in your cases. The reason being is that there is a statutory minimum coverage for bodily injury. As it relates to PIP, there is just a requirement that PIP benefits be provided, and as indicated previously, if the PIP policy is rescinded and there is no first-party no-fault benefits provided, then the individual can go to the Michigan Assigned Claims Facility if they do not have their own policies. Therefore, there is always some type of coverage out there. However, if all liability coverage is allowed to be rescinded, there would be no BI coverage whatsoever on the vehicle, and in essence, it would be uninsured. The only type of recovery would be for a uninsured motorist policy if the person maintained it. However, Titan v. Heighton does say that they could go out and purchase that. The most logical and apparently best potential practice would be to use Frost to avoid PIP coverage as to all parties, including innocent third parties. If you proceed down a rescission aspect, then all PIP coverages could be rescinded, as there is types of coverage for the individual to receive first-party no-fault benefits. However, as it relates to the BI coverage, it appears that based upon the State Farm case, as well as a closer reading of Titan, that BI should be only reformed to a 2040 coverage from any other higher limits, and any attempt to rescind all BI coverage for an insured involved in an Uber Lyft sidecar type situation would probably be met with severe opposition and ultimately potentially having the 2040 coverage placed in effect. There is the argument to be made that all coverages could be rescinded under Frost if you wish to remain that aggressive, and there is an argument to be made for that. However, there is the contra opinion of the State Farm case that had been previously cited, as well as it appears Titan in its footnotes seems to refer to having minimum limits for BI purposes. The Titan case does not reference first-party no-fault at all in the opinion. Some closing thoughts. Do not fear, legislation is in progress. However, legislation takes time, and as we well know, we can see that bills can die. Unfortunately, I wish the bill had been passed, and this webinar would simply be addressing the new legislation and how it affects no fault. But for now, we must deal with the cases of where we have claimants involved who are either driving an Uber vehicle, owning an Uber vehicle, or being passengers in one of these vehicles. As stated before, it does not appear that they would be considered taxi cabs underneath the no-fault priority statute. They've been defined in several other states as a transportation network company, as well as the structure of them appears to be not a taxi cab. So what are you left with? Well, since that's the case, you must decide what you want to do. Do you want to rescind? Do you want to reform? Do you want to just pay as you go and determine if there is other higher priority carriers? These are all your options. However, the recommended options are to determine if there's any misrepresentation in your application or the use of that vehicle that's been provided to your carrier. If there is, then you are left with rescission and reformation of the policy. Obviously, reformation would be to lower limits and to change optional coverages, such as getting rid of any UM or UIM coverage on the vehicle, which is purely contractual and is totally allowed under Michigan law. And then to reform the BI limits down to statutory minimums is also allowed. The bigger question is to rescind the policy and act as if there is no coverage on the vehicle. This appears to be an option for PIP benefits for all passengers of the vehicle, including the driver. However, as previously stated, the BI appears to present a problem due to the State Farm case and a closer reading of Titan. This is a slippery slope. Currently, I'm giving you the best options, or what I believe to be your best options in which to attempt to limit exposure on your claims. In closing, send the passengers home for their own first-party no-fault benefits, knock the BI limits down to statutory minimums, get rid of any UM optional coverages through a reformation, be aggressive in the handling of these, and when you document them, do not be afraid to gather information through the EUO process, as we will then have it under oath as to any type of misrep that the individual has done, rather than just a recorded statement. If the documents appear to be signed, accurate, and acknowledged by the individual, then the EUO does not have to be necessarily scheduled. But ask for a quick legal opinion. Call us, run the facts by us. We'll be glad to help you. Continue looking for our webinars as well as our no-fault news lines, and as soon as some legislation comes forward, we'll let you know, and enjoy the ride. This is going to be a wonderful evolving area, and as we've seen before, the Michigan No-Fault Act that has been in effect since 1973 is always an evolving animal. Look forward to working with you, talking to you. Any questions, comments, concerns, please give me a call. I hope you all have a great day. I hope this provided some information to you. There's my information at the end. Take care, and until we see each other again, have a great day.